welcome you all to today's event. I'd like to specifically talk about the banquet that we have tonight. We're going to have, you can get in at the door. It's $25 for dues paying members, $35 for non-dues paying members. But it'll be a really good opportunity to meet some attorneys, and there's a cash bar there. We'll start at 5:30.
Cash bar?
Congressman Massey and Professor Dr. Blackman will be addressing
Twice in a day if you can handle it.
But it'll be a good time. So with that, I'd like to just go ahead and really just jump into our program. So our discussion is on the constitutionality of 3D printed guns, and we're dealing with the First Amendment and Second Amendment. And this is a new emerging discussion with the invention of 3D printers really being specialized and being used in the home, and the specific components and the durability of them leading into the ability to make firearm parts out of them. And so this has really been a new age discussion of the Constitution, and I'm really interested to see what arguments come out of this debate. So we have Professor Katkin of Chase Law, and we have Professor Blackman of South Texas College of Law. So with that, I'd like to just give it to Professor Blackman to get started. Thank you.
Thank you all so much. It's a pleasure to be here. I clerked in Kentucky. I clerked for Judge Boggs in Louisville. I had a wonderful time here. I spent a lot of time in Cincinnati. It's always fun to come back here. You're all in for a treat today. I have not only one constitutional right, but two constitutional rights. How the First and Second Amendment protect the right to print 3D guns. Now, before I get started, who here has actually used a 3D printer? One, two. Okay, what'd you make, Sebastian?
We made a little scale model house.
A house? Okay. How about you? A keychain. Okay, very good. Okay, what is 3D printing? 3D printing is a model that allows you to design an object on the screen, whether it's a keychain or a car or a house, and actually create that object in reality. And the way 3D printers operate is with code. Code is simply another way of conveying ideas using words and numbers. So I'll give you a brief tutorial in 3D printing. Let's say I want to make a cylinder, right, a tube. And I want to make a cylinder with a radius of 5 inches and a height of 20 inches, so 5 by 20. I would write in the relevant language, create a cylinder with a height of 20 and a radius of 5. That's it, right? By designing an object on the screen, you can then create it in reality. And often 3D printed objects are fairly simple trinkets made of plastic, but they can become more sophisticated. They all come out of a device known as a 3D printer. This is what a 3D printer looks like. Here, they're printing a race car. Okay. Here, they're printing anatomical models like a human skull. All right. How does a 3D printer work? Who here has ever made a candle? Yeah, we've all done this, right? How do you make a candle? You take the wick and you dip in the wax, you pull it out, you let it cool, right? You dip in the wax, you pull it out, you let it cool. Every time you dip it, it gets a little bit thicker around the base. 3D printing works in the exact same fashion. But instead of dipping something into wax, you're spraying a very thin layer of plastic. You spray one layer of plastic, you spray another layer of plastic, another layer of plastic, and each layer stacks up. And here you can actually see the little nozzle spraying a little bit of plastic and making a blue ball. This thing moves around up and down. Sometimes it's heated so that the plastic can cool quicker, right? There are different ways of 3D printing, but it's all the same idea. Very thin layers printed one on top of the other. Okay, I want to show you a demonstration of how 3D printing operates. This will show you an object being created. And when you recognize what's being created, I want you to shout it out, okay? So first, layer comes down. You have this honeycomb lattice, this honeycomb framework, right? This is number one. When you see it, shout it out. Number two, see another layers get added. Number three, more layers get added. Number four, more layers get added. Anyone see it yet? Dinosaur, you're close, close. 5. Frog, closer. Toad, same thing's a frog, okay. 6. Anyone see it? Ooh, who said it? You're really close, but you're not right. 7. Ah, Yoda. Ah, so you were so close to Jabba. Very good. Usually people get it at this picture, but okay, you got it this one. Fine. Here, I'll finish it. There's Yoda, right from Star Wars. 9, 10, 11, 12, 13, 14, 15, 16, 17, and it's going to finish with the skull, 18. There you go, right? So you start with nothing, and then layer by layer, you print a Yoda bust. Now, I'm not talented. I'm not an artist, right? If you gave me a block of clay, I couldn't make that. If you gave me a thing of wood and said, you know, I can't make that. If you gave me a thing of stone and said chisel, forget it. No, you can't do that. But if you gave me a computer, I could design a Yoda head, and I could use the computer to help develop it in reality. The 3D printing lets you take ideas in your head and bring it into the real world. Now, 3D printing is not limited to Star Wars and keychains and things like that. You can make sophisticated parts that interlock. But of course, we're in America, right? And people have 3D printers. What do they want to make? Guns, right, of course. The very first 3D printed gun was known as a Liberator. This is actually the design of the barrel of the Liberator, the barrel of the gun. Now, I played a trick on you before. I showed you how to make a cylinder, right? Remember the radius and the height? The barrel of a gun is a cylinder. And if you can design the cylinder, you can make a barrel of a gun. It's not that hard. So a guy named Cody Wilson founded a company named Defense Distributed, and they found a way of designing this 3D printed barrel. They also developed this. Who knows what this is? It's an AR-15 lower receiver. This is the only part of a gun the government actually cares about. They don't care about anything else on the gun. They care about the receiver. You can print your own receiver. You can print your own magazine. But the crowning achievement for Defense Distributed was the Liberator. This is the Liberator. Josh, what the hell is this, right? These little squigglies, right? These are all the parts needed to assemble a fully functional handgun. There's the frame. There's the receiver. That little cylinder is the little barrel. The little squigglies, those are the springs that pull back the trigger. There's only a little bit of metal in here. There's a firing pin, which is a nail. There's a bullet. Okay, how does the bullet work? You take a firing pin, you strike the back of the bullet, makes the bullet go forward. The only actual functional metal parts are the bullet and the nail. This is what the Liberator looks like when it's fully assembled. Now, let me tell you something. This is not a good gun. It is a horrible gun. I'll prove it to you. See this rope on the floor over here? Why is there a rope there? You want to guess? Yeah, testing purposes. When they first started testing this, they would actually tie a rope to the trigger and stand very far away and pull the trigger. Why? This thing will blow up in your hand. Why? Plastic is a very weak material. For example, steel. When steel gets hot, it expands. When steel gets cold, it contracts. It's the perfect material for a gun. Plastic does the opposite. When it gets hot, it melts, and when it gets cold, it cracks, right? We've all done that. So you have to not only print the gun, you actually have to treat the plastic with a special chemical acetone bath to make it strong enough to withstand the combustion. And if you don't do it right, it's going to blow up in your hand. This is not a good weapon. It's garbage, right? It doesn't work well. But it still scares the crap out of people, right? It scares people like, oh my God, plastic guns, plastic guns. Let me tell you something else. They're not accurate. There's no rifling in the barrel. You can't aim the thing. The bullet just flies. It's basically useless. It doesn't work very well. But people, again, are scared of it. So is there a problem, right? Is there any federal law that prohibits printing your own gun. Well, let's walk through this. When I say 3D printed guns, this is usually the image people think of, right? Where you click print on your printer and a gun just pops out. Not exactly. There's a very long tradition in this country of people making their own weapons. Anyone ever heard the phrase zip gun? Yeah, I see people nodding. No one wants to admit it. A zip gun is a homemade gun, a gun you can make yourself. Google it. Okay, I found this one. This is a garden hose and a soldering iron. You just attach the two with a little soldering. Yeah, it's very easy. It's a gun. I found this one. This one was fun. If you take a keychain, you made a keychain, right? If you take a keychain flashlight and you hollow it out, you can make a gun. All you need to make a weapon is a metal tube. That's all you need. It's actually very easy, right? 3D printing a gun is probably the most expensive and complicated way imaginable to create a weapon or get a weapon. It's much easier to just buy one. I want to show you now a demonstration. Please do not try this at home. These guys are idiots. Do not try this at home. You can tell they have the flip phone. They're legit, right? This is serious. It's an old video, but it tells the story. These guys are going to make a rifle out of a rubber tube. That's it. I could take you to Home Depot in 5 minutes and buy all the parts needed to make a homemade gun. That's a hell of a lot more lethal than a Liberator. I can do it in 5 minutes. Let's demonstrate. They have a pipe. At the end of this pipe is a little metal dimple. You can really use anything you want. And what are they going to do? They're going to load a shotgun shell, that's that red thing, into this rubber tube. Ready? And they're going to jam the metal pipe into the back of the shotgun shell. Now, what's wrong with this picture? There's a lot of things wrong with it. But just shout out, what's wrong with this picture? They're indoors. Don't fire a gun inside. It gets worse. There's more than just they're indoors. What are they shooting at? They're shooting at a cardboard box. Okay, good. You can see there's several holes in the box. They've done this before. What's behind the cardboard box? Anyone see it? Wires. This picture makes it more clear. There's an electrical outlet right behind the box, plugged into a fan, which is turned on. My point is, it's easy to make a gun. These morons, they couldn't turn on a computer, they made a gun, right? Maybe they can, I don't know. But they don't need a 3D printer to make a gun. Okay, ready? They're gonna fire it. Ready? By the way, the reason I don't show the video is a lot of cursing. I can't play the video, it's too much. It's better, pictures are better. Okay, so here we go. Ready? 1, 2, boom. Yeah, yikes, they made a gun with nothing more than a piece of rubber tubing. Home Depot, $5. Shotgun shell, maybe a few dollars for a box. Anything sharp will do it. They could use a piece of wood. Really, anything would work. They made a gun. I think they actually hit their target too. And you can see they pull out the shell. It's smoking. Right? Again, when you use this rubber tubing, it doesn't melt. It can actually withstand the heat. If you do the plastic thing, it will just shatter. They're all proud. Look at this. You can see the spent shotgun shell. Okay, so now did our friends in the garage break the law? Federal law, at least, no. There might be local ordinances about discharging a firearm inside. I don't know. Maybe it's Kentucky has them, I'm not sure. But generally, there's no federal law that prohibits making your own weapon. Now, you can't sell it. If you sell it, you're screwed because you need what's called an FFL, a federal firearm license. Those are hard to obtain. But just if you make it for yourself, that's fine. Right? You just can't make it for someone else. So then why am I here talking about this, right? If it's perfectly legal under federal law to make your own weapons, who cares? The way the government has sought to stop 3D printed guns is not by banning the end product. They've done that, but those laws don't really have much juice. Instead, the government has tried to do something else. They've tried to make it a crime to share the information, to share the files that can be used to manufacture a 3D printed gun. Now, I've represented in court now for a number of years Defense Distributed. And we've argued that these sorts of prohibitions are a violation of the First and Second Amendment. Now, the basic tenet of the First Amendment, which I'm sure you've all heard of at least, is the government can't stop you from speaking unless they have a really good reason. This is what's called the prohibition against prior restraint. A prior restraint is where the government says, you can't say this. Now, they can punish you after the fact. And you probably do this in torts. If you libel or defame someone, they can sue you for a judgment. But the government can't stop you in advance from saying what you want to say. There are exceptions which are very narrow, and I'm not sure even those are good law anymore. But generally, you can't be stopped from speaking in advance. Now, you might say, wait a minute, Josh, this isn't just any type of speech. You can use a speech to commit a crime. Isn't speech that could be used to commit a crime outside the scope of the First Amendment? Not exactly. There's a very famous book, which I'm sure some of you are familiar with, called The Anarchist Cookbook. It's basically a terrorist hand guide. This teaches you how to make bombs, how to make poison, how to make other weapons. It's some bad stuff in there. And back in the 60s and 70s, when books still actually existed, government tried to keep this book off shelves in bookstores. And they said, you can't sell this book. And the court said, no, that's allowed, right? The mere fact that someone's speech may be used to help someone commit a crime doesn't make me bad. You need something more. You know, if I give you instructions on how to assassinate someone, right? So here's where he lives, right? Here's how to find him. This is a gun you're going to use. I just give you words. Okay, you can probably charge me with attempted murder conspiracy. I think that's an okay job, right? But you need something more. You need some sort of intent requirement. Merely sharing a file that someone else could use to violate a gun law or violate a murder statute is not enough for the First Amendment. Information, after all, is speech. And the mere fact that I choose to express myself on a computer and not with a canvas and paper doesn't deprive me of protected value. The Supreme Court said in a case called Sorrell v. IMS Health, the creation and dissemination of information are speech, right? It's not just creating it, but also disseminating it, right? Speech is a two-way street. I speak, you listen. There are two rights at issue, my right to speak and your right to listen. Two-way street. And this is something that the court has repeated in many contexts. We also know that we have data everywhere. I think it's an important question at what point certain types of code are no longer protected speech. The courts are grappling with this issue now, but what I would say at this juncture is the speech we have here is very expressive. It conveys ideas, it's graphical. People modify, people edit it. There's a lot of human interaction that goes on. Wherever the line is between protected and unprotected code, I think we're on the protected side by a large distance. Okay, I promise you 2 amendments. We'll turn now to the Second Amendment. It provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. In a famous 2008 case called D.C. v. Heller, this is Dick Heller, the Supreme Court held that the Second Amendment protects an individual right that is not connected with malicious service. And that this right guarantees the right of someone to keep a gun in their home. 2 years later, in a case called McDonald v. City of Chicago, this is Otis McDonald, the court extended Heller. And the court said that the right to bear arms applies to the states as well as the federal government. So it was incorporated, to use the lingo. So under current law, the D.C. handgun ban is gone, the Chicago handgun ban is gone, but the Supreme Court hasn't said much else out. In over a decade, they've really not had much more to say about McDonald since that time. Now this term, they actually took a case, probably argued next year, about the right to carry. So I don't need to go there for a minute. But I want to make a couple informed speculations about the Second Amendment. The first is the Second Amendment protects some right to acquire arms. Now, I'm not saying that there can't be any restrictions on the sale of arms. That's not my point. Rather, to have the right to bear arms, you have to get a gun somehow. Right? Imagine the government passes a law that says, if you have a gun, that's fine, you can keep it, but no one else can buy guns. We're going to a freeze, right? No one else can buy any guns. I think that sort of law would violate the Second Amendment, right? What's the point of having a right if you can't get a new firearm? Okay. The second right I want to talk about is what might be called a right to make arms. And this one I think is a little bit more historically grounded. long before there was Walmart and Cabela's, if you wanted a gun, you had to make it yourself. You manufactured your bayonet. You manufactured your musket. There's a very long-standing tradition in this country of gunsmithing. Indeed, to this day, there's no federal prohibition on making your own weapons. I think you have a right to make your own gun. Now, again, it can be regulated. Maybe they can't say you can't make a machine gun or you can't have a short barrel shotgun. I'm okay with that. But at a basic level, there's some right in the Second Amendment to manufacture your own arms. Why is this important? Let's think about what actually is going on with these sort of state laws. These state laws ban the sharing of information of how to make guns. This runs afoul of what I call a hybrid right that violates both the First and Second Amendment simultaneously. The government is stopping you from speaking about how to make guns, right? This implicates the right of speech, the right to acquire arms, and the right to make arms. There's a lot of stuff going on there. You know, for example, let's say the government passes a law that makes it a crime to say Merry Christmas, like an actual war on Christmas, right? It's a crime to say Merry Christmas. Is that a violation of free speech or free exercise, or both? Or the government passes a law that makes it a crime to teach people how to perform abortions. Is that a violation of speech or is that a violation of the 14th Amendment? These rights often reinforce each other in this regard. Okay. What laws are in the books now? The leading law in the books is called the Undetectable Firearms Act. Now, this law was not enacted in 2013 after Cody Wilson put the Liberator up. This law was enacted in 1988. This law is older than most people in this room. It prohibits having a gun without any metal in it. You're required to have any gun with a certain amount of metal to trigger a magnetometer. Now, why did Congress enact this law in the 80s? They were afraid of the Glock handgun. Now, the Glock is a very famous handgun. It's perhaps made most famous by Bruce Willis in the Die Hard movie. Here's a line from that movie. He says, "Luggage, that punk pulled a Glock 7 on me." You know what that is? It's a porcelain gun made in Germany. It doesn't show up in your airport x-ray machines, and it costs more than what you make in a month. Everything he said is false, okay? There is no Glock 7 that doesn't exist. It's not made of porcelain, they're made out of metal. They're not made in Germany, they're made in Austria. It will show up in an x-ray machine, and they're fairly affordable. But people were so afraid of this gun, which has some plastic parts, they passed a statute that didn't really matter. But the point is, we already have a law in the books that bans plastic firearms. They're illegal. You can't have them. Even the Liberator, to be lawful, they actually solder in a block of metal into the handle. So we already have laws that ban the end product, right? You can't have a purely 3D printed gun. In recent years, there have been efforts to expand it to ban all plastic guns, even with metal parts. Those laws have not gone anywhere. Some professors actually suggested that we should ban plastics so people can't 3D print guns. Not going to work. Why? You can 3D print metal. Yeah. This is a 1911 handgun. It's 3D printed from scratch. Now, you wouldn't want to do this because it costs $40,000 to make. This is a gun that you might buy for a couple $100 used. So this is not a smart way of developing a gun, but you can 3D print metal fairly easily, and this is very robust. Okay. Then how has the federal government gone after 3D printed gun files? They've used export control law. Now, when I was in law school, we never learned about export control law. It wasn't a thing we studied. But this is a big area if you want to get into international law. If you want to ship a PlayStation 4 overseas, you need a government license. Why? This is a fast microprocessor that might be used by bad guys to do bad things. If you want to ship, I don't know, a Stinger missile to Afghanistan, you should probably get the government's permission to do that. We like export laws. Those are good. Keeps our stuff out of bad people's hands. But the government went a bit too far. They relied on a regulation known as ITAR, which is International Traffic in Arms Regulations. And they said that shipping a missile overseas is no different than putting a file on the internet. I say it again. The government said that putting a file on the internet of how to make a weapon can be prohibited in the exact same way that actually mailing a rifle overseas could. Now, I think the argument's absurd. I think there's a huge difference between the actual gun itself and the data used to make it. But even if I'm wrong about the policy issue, we've argued at length that this regime is unconstitutional, that the government can't tell a U.S. citizen to not put a file on the internet. It's just about censorship. from start to finish. Even though the case makes most waves in the Second Amendment realm, we've always viewed this primarily as a First Amendment case. Let's fast forward. In 2013, the State Department sent Cody Wilson a letter, and they demanded they take off the internet the following files that can be used to make a number of different devices. They said that these files should be removed from public access immediately, right away. We sued them, and the case has been in court now for, God, almost 5 years. The thing about litigation, Mr. Cochran will echo me, it takes forever to get anything done. We actually made it up to the Supreme Court, went back down to the district court, then we got sued a bunch. So we keep going up and down. I think eventually this court will take the case, maybe in a year or so. These things do not resolve quickly. When you are studying law school, you get these thick case books where all these cases are done and finished, right? But in the middle, it takes forever to get a judgment. I think we're going to keep fighting for it. I'll stop here, turn it over to my friend Professor Cochran, and I welcome your questions later. Thank you all so much.
I'll try to keep my comments relatively short too, so we have time for student comments and questions. This is a rare treat for me because some of you know I was going away at the University of Colorado in the fall, and I actually had the opportunity to see Professor Blackman make this same presentation there. So when he was talking about coming here, I suggested to Sebastian, I'll be at a great advantage if I get to comment on a presentation I've already seen once before, rather than if I have to respond in real time. So I feel fortunate for that. So. The first thing I want to say is it's hard for me to really disagree in any way with any of the Second Amendment arguments that Professor Blackman has advanced. I think they're meritorious under the Supreme Court's current doctrine, and I think he's entitled to win his cases on that ground. So I'm not going to express any disagreement there. But I don't fully agree with the First Amendment arguments, and so you have to. He only has to win on one, and I think he can win on the Second Amendment arguments. But I have some concerns about the First Amendment arguments, and I wanted to talk about those maybe a little bit. You can respond to us to ask questions about it. So I have some difficulty with the idea of thinking about code that runs machinery as speech. I think the paradigm of speech is that you say something to someone, they can say it back to you. Speech kind of encompasses that there's going to be a human listener. Speech in the speech doctrine can be broader than just using words or writing words or drawing pictures. It can certainly include things like setting fires and taking your clothes off and things like that, which may seem like conduct. So there's a broad conception of speech in the First Amendment doctrine. But I think what all of that conception has in common, whether we're talking about spoken or written words, written pictures, expressive conduct, is this idea that there's ideas being communicated to a person. There's a person on the other side who is the audience for that speech or expression. And I think code, which speaks only to a machine as part of the machine's process, doesn't really fit to me that paradigm of speech. That you've got a 3D printer which is running in part because it has physical parts. It's made out of plastic. It has a motor. It has components. And then it also has some software code that's making it run. And I see the software code as just another one of those components. I don't see it as speech. So I don't think it's talking to anybody but the machine. I don't think it's exchanging ideas with the machine. It's just simply a part of what operates the machine. And so I really don't see that as speech. And I think we have in our free speech doctrine some lines of doctrine that reflect my views on this, although there's other lines that reflect Professor Blackman's views on this. But we have a lot of crimes for things like fraud, whether it's tax fraud or commercial fraud or mail fraud, where if you write down on your tax form, I only earned $5 this year. When you know that you earned $100,000 this year, that's a crime. And you're not going to be able to say, well, but that's just speech. I was just expressing myself on the form, and that should be First Amendment protected. Because the idea is that the harm is that you've actually deprived the government of the money. If you go out on eBay and you advertise products that you're going to sell, and you collect the money from people, and you just don't send the products, you just keep the money and put it in your pocket, That's mail fraud, right? And you're not going to be able to say, well, but I was just expressing myself. This was just my speech out there on eBay. You know, so I don't think every use of words or numbers or something you could write down counts as speech within the meaning of our free speech doctrine. I think there has to be this kind of notion that there's some communication, there's some expression of something, some kind of idea that's being captured in the form of the expression that a listener is supposed to receive. And I think this is even reflected a little bit in the area of computer code. And I know there's a lot of buildings on computer code. It's a new field. They go all different ways. But the one line that I'm going to talk about, and I'll let Professor Blackman talk about the contrary lines, and I recognize that they're there, is there's a statute called the Digital Millennium Copyright Act. And the Digital Millennium Copyright Act is designed to protect copyrights in the post-internet world. And one of the particular provisions in the Digital Millennium Copyright Act is called the anti-circumvention provision. And so what this provision says is, it is a violation of federal law to use software that will allow you to circumvent someone else's security software. So for instance, let's say you use an example that would be very familiar to you guys, because I know that sounded very dense, but you all use Westlaw, and you all have passwords that let you use Westlaw. There's a lot of things on Westlaw that are actually in the public domain. They're not copyrighted, right? So all the cases, all the statutes, everything like that that's up there are not copyrighted material. Westlaw has it. You can use your password to get on Westlaw and use it, but Westlaw doesn't own any copyright. Now, the Digital Millennium Copyright Act says if you don't have a password to Westlaw, and if you somehow come up with your own software code that lets you hack your way on there and use Westlaw, and you access those cases and those statutes that they need to charge people to access and that they need to require you to have a password to access, that's a violation of federal law, even though it's not a primary copyright infringement because the material itself might not be copyrighted. That has been challenged a few times on First Amendment grounds. The Electronic Frontier Foundation challenged it. There was a more recent case that went to the Ninth Circuit called Disney versus Data Angel. And the courts have always upheld that provision of the Digital Millennium Copyright Act. And they've said, well, using software code to break somebody else's security protection and hack your way into a password-protected website and take their services for free that they're actually charging for, that's not First Amendment protected activity, even though you're just using code to do it. And I think that's a correct decision. I think that the idea of the First Amendment presupposes some of the justifications that mainly Justice Brandeis talked about in his Whitney concurrence, and I know my students have recently seen that, that there's reasons we protect First Amendment freedom of speech. It's so that we can have a democracy, so that we can have freedom, so that people can self-actualize themselves, so that we can have a marketplace of ideas, so that we can have a venting function. I hope these words are ringing bells with some students, but I don't think any of that applies to the idea of using software code as a machine part. And so I just don't think it's part of the marketplace of ideas. I don't think it's related to self-actualization. And I just wouldn't extend First Amendment protection into that area any more than I would extend it into tax fraud or mail fraud or circumventing password protection. And I know some cases do go the other way, but some cases go my way on this. And so I think it's very much a progress type issue. The only other small handful of ideas I have, which are smaller than that one big idea, is that we also do have some First Amendment doctrine that allows, even where actual speech is an issue, allows regulation to prevent certain kinds of secondary effects. So this comes up a lot in the context of like zoning law that zones adult-oriented businesses, right? So say there's a First Amendment right for a hustler to have the hustler store. You can still have which you have here in Cincinnati. You can still have zoning laws that say, but you can't put that too close to a school or a church or someplace or a park because of the secondary effects that places like that tend to be magnets for prostitution and things like that. So that can be limited to certain places. And I think that kind of doctrine has a little bit of impact here. So I'd be interested to hear Professor Blackman talk about that you could be thinking about regulation, even if this is speech, even if I'm wrong, it is speech, that there's possibly room for, under current First Amendment doctrine, for some regulation to prevent those kinds of secondary effects, in this case, gun violence. Yeah, that's, and finally the prior restraint stuff that you talked about, I certainly agree that there's much stronger doctrine against prior restraints than against subsequent punishments. I'm not sure that regulation of code that can be used to prevent 3D printing of guns has to be seen as prior restraint. It might be under the current statute, but it could be, that statute could easily enough be amended to just allow subsequent punishment. So I think that's more, that problem seems to me more illusory than real. It could be just that if you had a law that said something like, well, if a gun is manufactured and then is actually used to commit a crime, that after that, the person who provided that software code could be held liable for that. I wouldn't see that kind of law as a prior restraint, although it would probably still raise some of the other First Amendment problems that Professor Blackman addressed. So those are my big points, and at that point, I return to Professor Blackman and then wait for questions.
Thank you so much. I'll keep my remarks brief because I want to have time for everyone to ask questions. I'll start with the secondary effects doctrine. You may have studied a case in Conlon called Renton, which is basically the city wants to zone strip clubs that have existed, put them all the way up by the boondocks. And the courts actually held that exotic dancing is for protected speech. So how can they tell you where you can perform speech? The court said, well, we're not regulating the exotic dance. We're regulating the people who hang out near secondary effects, the criminals, the vagrants, the pervs, if you will, right? We want to regulate those people. The district court actually ruled against us on the secondary effects doctrine. We argued vigorously two things. First, this doctrine has only been applied by the Supreme Court in the context of adult dancing. They've never applied it to actual speech that you would use with words and code and the like. And second, I think that doctrine is very much in a weak state. There was a case called Reed v. Gilbert a couple years ago which regulated signs, and the court made no mention whatsoever of secondary effects. So this doctrine, I think, is basically dead. I don't think it has much juice anymore. And to the extent it does, it's never been applied to us. Now, I thought you were talking about the Anti-Millennial Act. I'm actually favor that one. But the Digital Millennium Copyright Act, I think, is a very good example. The sort of code that's used to bypass encryption methods is what we might call an executable, right? Where you open up an app, it runs automatically, right? You take your phone, you click app, it runs automatically. That sort of code, I'm actually with Professor Kotkin. I don't think that is entitled to protection. The 3D code, I think, is actually different. It's graphical. It shows designs and blueprints. It requires a lot of human intervention, how to print it, the dimensions, the size, the scope. For me, what separates the executable code from protected code is how much human interaction goes into it. And I can tell you, printing with a library takes 40 hours. It's a lot of work. It's a very labor-intensive product. And maybe if we get to the point in the future where these things are completely automated, I can shift my answer a bit. But at least where the technology is now, this does have expressive value, and I do think it's warranted to protect under the First Amendment. And one of the biggest challenges they have in actually this case is explaining to judges and other people how this technology works. If you think it's just point, click, shoot, it's an easy case, right? But there's a lot of work that goes into it. I think I'm glad we're on the same page with the Second Amendment. I don't think it adds too much to the case other than to reinforce what already exists under the First Amendment. I'll stop there. I think it's good. And I want to hear more from the students what their questions are. Yes, sir?
So would you be of the opinion that when you take a code and create a 3D printed gun, it's similar in a way that an artist takes a new medium and creates something that we've done with the traditional medium?
Yeah,
way of speech?
That's a good example. Let me give you a hypothetical, right? Let's say I design a file to make a non-operational firearm, right? It may be used for a video game or something. And then you take it and then you modify it such that it can be used as an operational firearm. Under some of the laws in effect, I'd be liable even though I made a non-operational gun. Give you another example, right? Let's say someone has a handicap and they can't use their hands. And they're able to modify the design of a gun to trigger with their foot. This is actually real. People with disabilities have a Second Amendment right as well. There are a lot of reasons why people might want to use this technology to create something different than what predecessors have made in the past. What's called the maker movement, right? People who manufacture their own devices are very excited about this, right? Let's say you want to make a more precise scope for the rifle. You can tweak it. You can modify the specifications. There are books, go down to the library, of gunsmithing, of how to make your gun a little bit more accurate. If you're a target shooter, how to get just another inch of precision on your weapon. There are a lot of steps that go into using this code and making the gun that I think changes it. And it's not as people think, it's just you point, click, shoot, and you run away. Right? If you want to get a legal gun, just go to Cincinnati. You'll find them pretty quick. I'm sure there are places you can get them. But this is not how people are going to be trying to make guns in mass. That's another hand. Yes, yes, sir.
Just kind of a policy thing. Obviously, there's no technological capabilities of it being, workable right now as far as people making mass guns and distributing these and them actually being effective and worthwhile to make. But when it does, because technology always expands and there's always going to be a time where it does kind of turn into it is worth making and it is worth doing. Do you feel like it is somewhat your guy, like the people who are advocating for this, is it your responsibility to say, well, if this happens, we think that this should be in place? Kind of the policy argument as far as like if it gets to a point, which technology always expands, it'll eventually get to that point where they figure out how to make it worthwhile and how people can do it themselves. Like what would be maybe forward thinking of like the policy argument?
Sure. I'll answer the question two ways. I've been involved in this thing for almost 7 years, and the technology hasn't moved a damn inch. Plastic sucks, right? There's no science that will make plastic a good way to make a gun. It's just not going to happen. It's brittle and it melts. But I'll take your question. I think it's worthwhile, right? Is it our burden to try and find a way to justify this? No. In constitutional litigation, when you have an enumerated right, First Amendment issue, it's the government's burden to justify this problem exists now, not that it might exist in 10 years. You study in common law the idea of the rational basis test, where the government can move incrementally and maybe ban a little bit now and ban later, and maybe take action now for something that doesn't even exist yet. I'll give you that for rational basis review, not for the First Amendment. They have to articulate a clear and present danger, if I may use the phrase, something that actually exists now to ban, not that it might be a problem in 10 or 15 or 20 years in the future. That's a very good question. There's a question in the back?
Yeah, we were just learning about the Prior Restraint Doctrine.
Good.
The other day.
Perfect timing.
And, I'm a
This in common law 1?
yeah.
Common law 2, okay, very good.
Yeah. And I am a little interested as to how do the provision of not just firearms, but also writing other blueprints in general would apply under prior restraint argument. Right? Do they have the same problems that firearms do?
You mean just regular paper blueprints? Is that what your argument?
Yeah, and electronic.
Right. I mean, look, so here's the irony of this case. If you go to the patent and trademark website, right, the PTO, you will see thousands of blueprints of how to make guns on a government website. Thousands of them, which are much more precise than the files we have. Right? It's not new. People have been putting instructions how to make guns forever. The reason why I think this case is viewed so differently is because people have this image that, you just click, point, shoot, a gun pops out. That's simply not how this technology works. And half of my job is explaining the actual technology. That's why the first half of my PowerPoint was just showing you how 3D printers work and how this code operates. That's half the battle. But if you accept the point that the sort of files we have are speech, then this fits neatly into prior restraint doctrine. It's pretty easy, right? I think the government can punish you for having the plastic gun. I haven't made that other point, right? I think if the state wants to ban a fully plastic firearm, I'm okay with that. That's the end product. But the sharing the information, they can't. Let me tell you something. Most people who download these files never print it. It's a lot of work. It's expensive. Most people download this to actually look at it, to study it. They even study it in museums and art galleries and universities as an engineering feat. There's value here other than actually making the gun. And these laws sweep far too broadly what's called overbreadth in sweeping and protected speech. Other questions? Yes, sir.
You made a point that there are no federal laws or regulations that really apply to the printed gun.
There's just the Undetectable Firearms Act, which says you can't have a fully plastic weapon. That's the only federal law.
So Congress, if they wanted to, they could regulate it. under
Regulate the gun or the information?
the gun?
Well, they already do regulate the gun. They ban plastic firearms.
Right, okay.
But you're asking, could they regulate the files?
Yes.
No, they can't. And they've tried. They've actually tried using federal export control laws to regulate the files, and that's what we've been suing about for the last 5 years or so. We'll get a judgment eventually. Eventually, we'll get it. Okay, any other questions? Yes, sir, in the back.
Well, what about the modification of existing weapons? So what if you could print out something, hypothetically, which is possible, to print out something that modifies something like an existing weapon to turn from semi-automatic to fire, like fully automatic? Is that protected, or where we draw the line? So that needs to be regulated versus
Well, again, if you convert a semi-automatic weapon, that is, you pull the trigger once, one bullet comes out, and you convert to an automatic weapon where you pull the trigger and it sprays, right? I think the state can, under Heller, prohibit that end product. I don't think they could ban a book that teaches you how to modify it, right? I think there's a difference between providing the instructions of how to do it versus actually doing it. Now, if I walk you through step by step, I say, okay, file this off, take this, put this screw in, I give you step by step how to convert the gun, I think I could be charged as an accomplice, maybe a conspiracy to possess an automatic weapon, right? But the key point is what's called scienter, or intent. You have to have something more than merely publishing the instruction for a general audience.
Is that called again? Scienter intent?
Intent, scienter. It's S-C-I-E-N-T-E-R. It's basically a synonym for intent, but it sounds fancier. Scienter. You came to here, got some barbecue, learned a new word. I'm from Texas. I do not eat barbecue outside the state of Texas. It's just I can't. I feel like a traitor.
bourbons are a thing here, so. you're okay.
I did the bourbon trial. I lived in Louisville, so that was good. All right, any other questions? Thank you all so much. Thank you, Professor Cochran.